Charities often approach law works with questions about how they can terminate their lease. If the lease contains a break option, that can be exercised. The organisation needs to be aware, however, that it will need to strictly comply with any conditions applying to that break. We would always recommend legal advice is obtained before exercising a break option. Failure to comply with any preconditions could mean that the right to break is lost. If a break option was not negotiated at the start of the lease, then for a full release of its obligations, the charity should seek to surrender its lease to the landlord. The landlord is not obliged to accept a surrender. Charities should also note that under the Charities Act 2011, a surrender of a lease is considered to be a disposition of charitable land. Therefore, the surrender will need to contain a Section 1228 Charities Act 2011 statement, and trustees of a non-exempt charity must give a Section 1223 certificate. If there is no break and the landlord will not accept a surrender, then depending on the alienation clause in the lease, the tenant should consider assigning the lease or underletting the property. Underletting part of the property may be possible, depending on the provisions of the lease. An underlease of part could be useful where the organisation has surplus space or to reduce overall rental costs.